public records requests regarding hydraulic fracturing operations, while also limiting its publicly available information on its website to obstruct potential legal challenges to the department's permits for fracking operations. I've personally made over a dozen public records requests to ODNR's Oil and Gas Division over the past 5 years, and I have also sued that division 4 times to enforce the provisions of Ohio public records law during that time. I'd point out initially that Ohio's public records law is actually a very good law on its face, very broad on records, and importantly, it requires that all state agencies very promptly and within a reasonable period of time supply requested records to members of the public upon request. Courts have interpreted that time period for relatively well-limited records requests to be as little as 4 business days before a state agency is in violation of the public records law. However, none of those public records requests I mentioned have been responded to promptly, but have lingered from 6 to 8 weeks or longer. ODNR's system simply seems to have no ability to respond to any request, irrespective of its breadth, any sooner. When I contact DNR to inquire about the status of my requests, I am told only that there are so many requests that they cannot get to them any quicker with their existing staff. However, I would point out that the oil and gas staff has increased from 44 members to 128 members between 2011 and 2016, during which time their records performance has only deteriorated. Obviously, no serious priority is being given to records requests in that program. And I'd also say that records requests sent to other divisions of ODNR are dealt with fairly professionally and promptly. In each of my 4 lawsuits, the state attorneys conceded that ODNR was in violation of the public records law due to their lack of a prompt response, and the lawsuit only involved getting the state attorney general's office to force the records out of the department. In 3 of the 4 cases, I received the maximum statutory fine of $1,000 for ODNR having violated the public records law. In each case, the fact of violation was immediately conceded by the Attorney General's office, which made no effort to defend ODNR's conduct. Based on this experience, it is obvious to me that DNR is in habitual, chronic violation of Ohio's public records law and is doing nothing to come into compliance. I also want to point out to the panel that to compensate for its failures, DNR is using multiple strategies to put off public records requests from citizens. The first is to simply say that their legal staff must review all requests, and that is the cause for the extensive delay. However, very few requests for documents involve significant legal issues. And this extra step, which seems to have been instituted primarily to prevent the release of potentially embarrassing documents, does not justify much delay. Second, and more pernicious, is that after a lengthy delay, DNR sends the requester a form letter stating that the request is so vague that it must be rewritten before any response will be given. This reply may be a serious roadblock to citizens with limited background in the legal requirements of the public records law, who ODNR puts on a treadmill of constantly rewriting their requests to meet ODNR's never satisfied level of clarity. This was even tried against me once on what had been a very specific request that led to my immediate filing of a public records lawsuit. The issue of vagueness was never raised as a defense by the Attorney General's office, and I again received the maximum penalty of $1,000. for ODNR's violation. Now third, and this is more recent, I've been told by citizens of a third evasion strategy from DNR. Citizens requested through a public records request documents about a cleanup of a spill of fracking chemicals. They were told by DNR that the records could not be given because the company claimed they were trade secret. Now, this was public health information. And notice that DNR said that they were being withheld because the company made the claim. There was no independent evaluation of the legitimacy of the trade secret claim made by DNR. Also, most of the time with trade secret claims, the records are provided, but the trade secret information is redacted. It's blacked out, so it can't be read. This was not done. The entire document was held back. Now, the citizens would have a lot of difficulty in prosecuting that case. I hope someone's able to bring that case, to bring this new strategy under control. I also want to point out that Ohio courts, and very conservative, very pro-corporate, very high campaign contribution courts, particularly the Ohio Supreme Court, have been cutting back the effectiveness of the Ohio Public Records Law. This is being taken advantage of very much at DNR. Initially, and I'm talking here about 10 years ago, $1,000 maximum fine was payable for each record withheld. So if you had 5 records to be given to you, there was a $5,000 maximum penalty. That's now been cut back by the courts. So now there's a maximum of $1,000 irrespective of how many records are withheld, even if it's 500 or 600. But more importantly, the public record statute's most significant deterrent effect historically has been an award of attorney's fees for if the agency is in violation. Simply by my filing a lawsuit and that lawsuit having a determination that ODNR was in violation of the law, a citizen could get their attorney's fee paid. The first 2 lawsuits I had against ODNR, I recovered $9,000 in attorney's fees in the first case, $2,700 in the second. These would be effective deterrents against an agency like DNR to get their public records duties quickly responded to. But in 2014, the Ohio Supreme Court changed all that. The case DeFranco versus South Euclid, they held, no, we're only going to allow attorney's fees when a court order is actually issued that the records have to be forthcoming. This was an open invitation to DNR to just hold on to records, wait for the lawsuit to be filed, and then supply the records. By supplying the records, the lawsuit becomes moot. It's dismissed for that purpose before the judge has an opportunity to issue that order. In this way, attorney's fees have been removed. There's only the $1,000 fine, and as DNR's made plain, it's more than happy to pay that slap on the wrist of $1,000 rather than going through a system of really reforming its record system. We've heard the highlights of about a little less than half of my written testimony. I hope you will give it full attention. It's clear to me that the activities of ODNR violate Section 10 of the Rio Declaration on Environment and Development from 1992. Also, it violates Section 19 of the UN Human Rights Committee's International Covenant on Civil and Political Rights. Thank you very much, and if you have any questions, it'll be my pleasure to respond.
Thank you. I have one question for those who don't understand Ohio law. If the Attorney General is not denying the $1,000 fine for the purpose of they did wrong, why is it the Attorney General, who isn't he the big lawyer for the state of Ohio, why wouldn't the Attorney General do something about the records people and clean up that mess so that it gets fixed, and he's not in the position all the time of saying, yeah, pay the $1,000 or whatever, I'm not going to contest this. Because by not contesting it, he's admitting it's happening, is what I heard you say. Does he not have the authority as the Attorney General, the lawyer for the state of Ohio, to demand that that gets changed within the agency?
I have quite a story to give you, Ms. Gibbs, in response to that. I mentioned my first lawsuit, I had a recovery of $9,000 in attorney's fees. That was a suit brought by an environmental organization to request the documents from ODNR about its implementation of House Bill 113. That was the bill that opened up Ohio's public parks to fracking. And the bill had been passed for some time, as we were aware of a lot of activity within ODNR to implement that legislation. I made the request to have that information come out. Of course, that was politically sensitive, but that's no defense to the public records law. The records were eventually supplied to me, and the Assistant Attorney General, who was a section chief, very senior person, said that this was his first time he had personally been involved in one of these ODNR suits. He was shocked at the unpreparedness of DNR to supply those records, and he said he personally raised this with Attorney General Michael DeWine, former United States Senator, current Attorney General as of this day, and that the Attorney General was concerned enough that he did raise it indeed with the Director of Natural Resources. That's the last I heard about that situation. I can tell you, while I believe Attorney General DeWine's concern was no doubt genuine, it did not make any difference in the Ohio Department of Natural Resources.
So there is no legal or job requirement by the Attorney General to make sure that the state agencies, whether it's ODNR or Health and Human Services, does their job? He is their attorney, so he has that advisory role to that. He can certainly advise them, you are in chronic habitual noncompliance. He cannot, however, force the agency to make its changes. And again, those changes simply have not happened. It is not only chronic, I do believe it is deliberate. Earlier witnesses testified to the fact that they feel a great deal of hostility in contacting the Department of Natural Resources. That is certainly my own personal experience. They are extremely comfortable interacting with the business community, with the fracking industry, but they have very limited opportunities for interaction with the public at large. And indeed, they seem to be reluctant to engage with citizens. They do so at arm's length in these few public type opportunities they put together. They are afraid of citizens. They don't know how to communicate with citizens. We are such an afterthought in their minds. It's something to be avoided. That's certainly reflected from the lowest level that I've interacted with to the very highest. So my last question was, Nancy, you have a question?
Oh, well, are there ways that in particular that you can see that this delay in providing the response to the request serves ODNR?
Yes, in fact, that's the second half of my testimony. I wasn't able to get to it. So very briefly, time matters, particularly when it comes to the appeals process. Now, some permits are not appealable at DNR. And it's funny that those are the permits that are actually required by DNR to give notice to the public about. And these are like the drilling permits that are the only permits necessary for the actual fracking production wells. It's a simple permit, but it has to be publicly noticed, and when it's issued, it has to be posted on DNR's website within 2 days. That's important normally because there's an appeal process under the law. You have 30 days to bring an appeal, so you need to know when the permit's issued. But let's take any other permit that they have. For instance, there's a permit that actually authorizes the beginning of the injection process. There's a drilling permit, and then they have to get a subsequent approval, and that's also a permit. It's done by director's order to actually begin injecting the contaminants into the groundwater. That's a critical permit that if you want to appeal that, you have to do so within 30 days. But there's no public notice of when that's put out. So the only way you can find out about it is to make a public records request. And to do so repeatedly, because if you make a public records request on Monday and the permit comes out Tuesday, ODNR will not send you that permit, even though they don't look at your public records request until Wednesday. Well, if you have a 30-day timeline in which to bring your appeal, and it takes you 2 months to have them respond to your public records request and give you a copy of that permit, obviously, you do not have a meaningful right of redress throughout that appellate process. By having this process, they can frustrate citizens' appeals in this fashion. That is insidious, that's wrong, and that violates a lot of the UN charters that we're looking at here in this tribunal process. And that's now being repeated. They've just put out a new permit. This is for the well pads. You know, they're actually gonna go out into the field and build these well pads. That's pretty critical to the safety. It's the same process as the injection permits. There'll be no notice, and you go through the endless loop of the public record system.
Well, we heard from the first speaker this morning. I think, Felicia, were you the first?
Third.
Third speaker this morning, that they didn't know that the deep well injection wells were even there. Part of it was the lack of knowledge. Part of it was a lack of notice, not knowledge. So if that speaker wanted, there was no notice, or the notice was in a newspaper that she didn't get.
Right.
But if she could not afford an attorney such as you, how would she even know, because we've already established their website is short on qualifying for all people within the state, people who are blind, people who have different language, so forth. How would she know how to even, or that she has to file for a records request to get the information to then oppose it, whether it's 30 days or 60 days, what? How would she know when she's in a community like that? Because that's what she said she did not know.
By becoming very expert in computer science and by spending a little part of every day, or certainly every couple days a week, committed to that. Get in the situation that Felicia testified about, there was a little notice in the legal notice section that we all see in the newspaper and virtually never read. It was not in her local newspaper. She would have had to have had an absolute stroke of luck that she just picked up the Athens paper that day and looked in the legal section and saw it. And that would have only been that the application was filed. She then would have had 15 days to make comments. But there's virtually no information given it. And think about it. What's the critical thing in these wells? It's what's the geology in that site? Is it safe geology? What's the design of the injection well? Is that safe considering that geology? How can any citizen in 15 days come up with a comprehensive, professional, expert geological examination of that situation and get comments? So the fact that there's that notice given to Felicia for 15 days has no real world value. Now, when the permit's issued...
Well, wait, let me stop you there.
Yes.
So I have one other question. So when the notice is put in the paper, part for the record, when the notice is put in the paper, does it say things in which a lay person, a farmer who's got fields, could read it and say, aha, this is a nasty thing that I might not want, or aha, this is a wonderful thing that I really want to embrace? Is it described enough, or does it is it mumble jumble legal stuff that your average person could pick up that paper by accident or on purpose and read that and say, I get what it is, and now I need to figure out what to do?
It's very dense legalese. It's initially written and proposed by the company applying for the permit. They pursuant to general forms that ODNR does. The company puts it together, they give it to DNR. DNR approves whether it's fine, and that goes into the paper. It's extremely dense. It does indicate that an injection well has been applied for. It gives certain geographic indications as to where that would be, but I think you probably need a GPS system to really nail it down at that point. But as to its amount,
But if
as
you
to-
didn't understand what an injection system is, then you wouldn't really understand what they're putting there.
It might as well have been written in Swahili. Yes.
That was why I mean, you really have to sort of understand this in order to understand the notice.
Mhm.
And so if you're a farmer who knows nothing about fracking, injection wells, pipelines, any of that stuff, and read that, it would not necessarily raise a flag for you.
It would probably confuse you greatly. The word injection well would be there, so if you know what that word means, you would probably be put on inquiry notice, but then where do you go to get that information?
Great, thank you.